Welcome to the third in the Pillars of Democracy series, sponsored by the Library of Congress in partnership with the American Enterprise Institution and the Brookings Institution. I'm John Haskell, director of the John W. Kluge Center at the Library of Congress. We live in a challenging time. Polls show that major institutions in American society, in government and in civic life, are less trusted and less respected than at any time in recent memory. In an effort to grapple with the question of how their decline can be counteracted, we are bringing together historians, political scientists, legal scholars, authors, and practitioners from across the ideological spectrum. The idea is to create a fuller picture of the challenges facing American institutions and their potential promise. Last month, we looked at the US presidency. Today, we consider the state of the federal judiciary, and especially the Supreme Court. Thank you for tuning in to the third of these important conversations. On the panel today, we have Adam White, a senior fellow at the American Enterprise Institute, where he focuses on American constitutionalism, the Supreme Court, and the administrative state. White teaches at the Antonin Scalia Law School at George Mason University. He previously practiced constitutional and administrative law and was a research fellow for Stanford University's Hoover Institution. He started his legal career as a law clerk for Judge David B. Sentell at the U.S. Court of Appeals in the D.C. Circuit. Next, Kathleen Keaveney, a scholar who focuses on the relationship of law, religion, and morality. She is the Darrell and Juliet Libby Professor at Boston College, a member of the Massachusetts Bar. Professor Keaveney clerked for the Honorable John T. Noonan Jr. of the U.S. Court of Appeals for the Ninth Circuit. She was the 2018-2019 Carrie and Ann McGuire Chair in Ethics and American History at the Kluge Center here at the library. Last, we have Randall Kennedy, Michael R. Klein Professor at Harvard Law School, where he teaches courses in contracts, criminal law, and the regulation of race relations. He served as a law clerk for Judge J. Skelly Wright of the United States Court of Appeals and Justice Thurgood Marshall at the Supreme Court. He is a member of the bar in the District of Columbia as well as at the Supreme Court. He was awarded the 1998 Robert F. Kennedy Book Award for Race, Crime, and the Law. Mr. Kennedy's most recent book, Say It Loud, came out late this past summer. Our moderator today is Russell Wheeler, visiting fellow in the Brookings Institution's Governance Studies program and president of the Governance Institute. From 1977 to 2005, he was with the Federal Judicial Center, the federal court's research and education agency, serving as deputy director for the last 14 years. Wheeler teaches at the Washington College of Law at American University. Please note we are leaving time for questions at the end of the conversation, and you may submit those through the chat function on Zoom. Also note that all questions and comments on the chat must meet the standards of respectful civil discourse at the Library of Congress. Any vulgar content and personal attacks will not be tolerated. Let me turn the stage over to Russell.
Thank you, John, and welcome to this discussion of the American judiciary, and as John said, more particularly the Supreme Court of the United States, one numerically small slice, but obviously a very big part of the American judiciary. The court starts its next term, its October term, next Monday, and that promises to be a rather contentious term, a lot of blockbuster issues on the docket. And it comes at a time we have three national surveys about the court. One of the questions asked was, of the three branches of government, which one do you trust? The respondents said 16% for Congress, 27%, 25% for the presidency, and the Supreme Court 58%. So comparatively, the court's doing fairly well. But in all three surveys, public approval of the court has declined. Most noticeably, the Gallup poll, 40% of the people said they approved of the way the court was doing its job. That's a low over a 20-year period. The answer to that question on the other two, the Quinnipiac and the Marquette poll, range from 37% to 49%. And perhaps sensing that, some of the justices have been fairly outspoken in their views of misconceptions of what the court does. It started with Justice Breyer last May, the Scalia lecture at Harvard, and he has recently published this little book, the Authority of the Court and the Peril of Politics. And Justice Breyer worried about the media who identifies the party, the appointing president of a judge, and the confirmation process, which led, he said, it creates the popular perception that justices are unelected political officials or junior varsity politicians rather than jurists. That is now how most judges see themselves. Nevertheless, it has become a matter of concern. This is what the public thinks. More recently, earlier this month, Justice Barrett was a little more punchier in her remarks. She told an audience in Kentucky that she was there to convince them that this court is not comprised of a bunch of political acts, her words. She said the media reports of decisions, she said, makes the decision seem result-oriented, but she added judicial philosophies are not the same as political parties. And then a few days later, Justice Thomas, speaking at Notre Dame, worried that, in his words, the media makes it sound as though justices are just going right to their personal preferences. The public thinks, he characterizing here, he said, we are not acting as judges. You become a politician. We want a particular outcome. That it's all just personal preferences, a view, of course, that he rejects. So let me ask the panelists. Basically, I think what the justices are saying, they're saying we make decisions based on, it's more complicated. We make decisions based on law. People think we make decisions based on politics. But very rarely do they define politics. Justice Breyer said it's about who elected you, or a Republican or a Democrat. One might argue that depending on how you define politics and how you define law, it's very hard to say that the Supreme Court is not a political institution making political decisions. I wonder if any of you had any reaction to that observation. Randall?
It seems to me it's quite clear that the Supreme Court of the United States is political. How could it not be? If you get to be a justice by being nominated by a president, and you get to be confirmed by, you're confirmed by electoral politicians. How can one explain the fights over confirmation if this is not political? Frankly, I think that the comments that were made by Justices Breyer, Barrett, and Thompson were actually, to be quite blunt about it, ridiculous. And by that, I mean actually deserving of ridicule. Of course, the Supreme Court is political. All three justices were basically saying, trust us, we're above politics. They were all talking about various methods to shore up their legitimacy. And I think one of the things that's going on is there's frankly more realism about what the justices do. In your remarks, you made there was a sentence there in which you talked about the importance of focusing on law. I think that there's law and there's law. The justices often, there are many opinions, or there are many decisions in which the justices are unanimous. There are some decisions in which you would have ideological adversaries agreeing. Let's say Justice Thomas and maybe Justice Sotomayor may very well be agreeing on certain sorts of cases. But the cases that most concern people, the cases that are the blockbuster cases, the cases that are on the front pages of the newspapers and that are most volatile, those are the cases in which the priors of the judges, whether the priors be ideological, partisan, religious, those are the cases in which clearly, yes, the court is political.
I agree. I'd like to also draw a distinction, I suppose. I think, of course, the court is political. The root word of that is the Greek polis, or city or city-state, and it's analogous to the Latin word civitas, or cities. So the court's political. It's a civic institution. It's essentially concerned with the well-being of our community. But I think what we're worried about is that the court is being partisan, not just political. And I think that's a great danger, because the Latin word for that is pars. Partisans care about the well-being of part of the country, not the whole country, either in the strong sense that they really only care about their base, or in the weaker but not less dangerous sense that they're only open to the perspective of their base. about what counts as the common good. And partisanship on the court, I think, undermines the rule of law, which is meant to be, equal and is meant to be applied fairly and independently adjudicated. And you can get that definition on the court's own website. So what we're really worried about is that the justices have partisan constituencies who put them on the court and expect a certain kind of fealty from them as a result of that. And that means partisanship on the court is feeding into and also destabilizing, partisanship in the culture wars. A crisis in the judiciary is sort of a crisis in the democracy. We've got Bill Bishop's The Big Sort. You've got James Davison Hunter's culture wars. And so we have this coming apart that the court is part of and is in some sense possibly exacerbating.
I'd say at a very high level of generality and simplicity, politics is the realm in which we have choices to make, and they're value-laden choices. And law at its ideal is the place where the decisions have been made and they bind. And of course, that's an oversimplification. And in the middle, we often find the courts, especially the Supreme Court, which exercises some discretion. I'd agree with some of what was already said. The court, the justices are selected through a political process. Their decisions have political ramifications, and there are political blocks organized around the court. At the same time, I'd say I wouldn't necessarily agree that everything the court does, and I wouldn't say that Randall or Kathleen have said this, but it's not that everything the court has done is political. And even through the court's history where it's made choices, all the way back to, say, Chief Justice Marshall, whose decisions construing the Constitution certainly entailed choices with real ramifications for our politics and the structure of government. I think the challenge in all of this is to encourage and demand a judiciary, especially a Supreme Court, that even when it's making choices, those choices are themselves rooted in something outside of the justice's own desires, their own view of the good. And so for me, the ideal in the judiciary, especially an American constitutional judiciary, is one in which the realm of discretion that judges wield is as narrow as possible. And even when they are exercising discretion, that exercise of discretion really is rooted in more fundamental principles of American Republican constitutionalism beyond just the discretion of one particular judge.
So we have, thanks, we have, in a sense, two definitions of politics here. There's a sense that because judges are caught up in the partisan turmoil near their selection, and they have their own values, there's a certain political there. But then, as Kathleen says, politics in the broader sense refers just to the operation of the society. My old teacher, David Easton, the authoritative allocation of values. So the court is political in both those senses. And of course, it's true. You don't see it so much on the Supreme Court because of the small number. But we do know that about the best predictor of a federal judge's decision is the party of the appointing president. It's not a real good predictor. It doesn't predict an awful lot, but it predicts more than most anything else. And there, the case is almost prima facie. We get back, though, and Justice Breyer conceded that in his book. We can go into that more if you want to. Putting aside the fact that obviously ideology and a sense of proper public policy inevitably influences judges' decisions, there is a view, though, that the court loses its legitimacy if the public gets the idea that these are unelected people making decisions that legislators make and they can be recalled. Is that a legitimate concern for judges to, in a sense, promote we'll call it the myth or the fiction that all the judges are doing is, as Justice Roberts said, calling balls and strikes, or is that dangerous teaching? Any thoughts?
I'll start on that one because I've just been spending the past week or so rereading Alexander Bickel's The Least Dangerous Branch. And my goodness, he's really, even though it was written many years ago, it's a tremendous, I think, diagnosis of the problem that we have right now and that we've had for many years. It's just a more exacerbated form of it. And I think, unfortunately, the justices, and particularly Chief Justice Roberts, when he says, all I'm doing is calling balls and strikes, he's actually exacerbating the problem. Bickle talks about a vicious cycle we have between people advocating a literalist reading on the one hand, which says that all that judges do is read and decode the Constitution. And then when that's debunked, then we have this swing the other way toward a realist understanding of what judges do, which says they only make policy, imposing their will without restraint rather. And when then that's resisted, people flee back to the first pole. And Bickle thinks this is really dangerous. And I agree with him. And I think that we've got to do a better job of explaining what it means to be a judge, in the common law tradition to the people. So Bickle, I'm just going to read this one quote because I think it's really amazing. The people of a democracy, he says, must be mercifully soothed when they find themselves ruled to whatever extent by the 9 men of the Supreme Court. We know what the people imagine. They imagine that they rule themselves, and they imagine Marbury versus Madison. To the extent that this is not so, some explanation may be found or even made up. It would be no sin. It has been done before, but it is very dangerous. To begin with, the illusion is a two-edged sword which can be turned very sharply against the court. What is even more ominous, the illusion may engulf its maker and breed, as it has occasionally done, free-ranging activist government. When this crisis goes on, he says, the truth is that the illusion of judicial impotence and automatism, when fostered, be first acquired by the people and last with the accompanying feel of omnipotence by the judges. But it is also first lost by the people and last by the judges. One day the judges may abandon it too late. So what I'm afraid is we are caught in this bind between two false understanding of what judging is, either just literal interpretation or pure policy. And we go back and forth, and finally we're going to corrode the whole enterprise.
If I may, the mention of Bickle made my ears perk up. Bickle for me is in many, many, many ways the ideal. I actually keep a copy of his Yale portrait in my office on the wall, and I often look up at it and feel that I'm falling short of his example.
Not hard to feel, is it?
It is, but in many ways, now that you mentioned that, I think maybe that's a good way of thinking of judges and when they talk about balls and strikes. I do think thinking of a judge as an umpire is the ideal. Balls and strikes might be the wrong metaphor because the strike zone is pretty well defined. In other sports, sometimes umpires have to make judgment calls. And so I don't think the umpire metaphor is totally inapt. And in some ways, I like it when judges talk about themselves and umpires, even when we know judges often fall short of that ideal. I think it's good that they hold it up as the ideal, that they strive and challenge themselves to be as close to the ideal as possible, even if we know they'll never achieve perfection. And also then it gives us a sort of a metric by which to judge them and hold them accountable too. And so even if we know that the ideal of the umpire is maybe just slightly beyond our grasp in the affairs of government, I still think it is what we should strive for.
I disagree.
Mhm.
I think it's a delusion. I think we should make our peace with an understanding that the Supreme Court of the United States, it's political. It has now there's different registers of there's different ways of carrying out politics. So the presidency has certain tools, has certain traditions, has certain ways that it goes about its business. The legislative branch, the same thing. The Senate acts differently than the House of Representatives. And the Supreme Court, I'd say the same thing. Now, all of them have the good effect of decentralizing power,
Right.
Checks and balances. But I think we should make peace with all of them are lawgivers, all of them are wielders of power. And to go back to Kathleen's comment, her first comment, can it really be said? I mean, the regular person in the United States of America today, if you have a case involving, let's say, organized labor, if you are a unionist, is it sensible for you to look up at the Supreme Court and to think that, well, you know, the majority is really not so much against us? It seems to me quite clear
Right.
that the Supreme Court of the United States is, you know, generally unfriendly towards the interests of organized labor, quite friendly towards the interests of business, quite unfriendly towards, let's say, consumers, and one could go down the line. I don't think that people are being unduly paranoid or unduly cynical if they take a look at how the Supreme Court has acted over the past, you know, let's say 10 years and come to and comes to those conclusions. Now, does this mean in every case? No, of course not. But are there very strong tendencies which should lead someone to think that, generally speaking, if there's any ambiguity, the Supreme Court is going to go one way as opposed to another way based on their ideological priors?
Well, and the other point you can, I think, insert in this, and I agree with what Professor Kennedy just said about like looking at prediction, but even judging itself, our model of judging, you know, that the whole Constitution is based in, of course, is the common law system, right? And you know, and both Professor Kennedy and I teach contract law, which is just this wonderful way of introducing students to the common law system. And what you see is that the process of judging in the common law system on even these very homely matters of contract law is not calling balls and strikes. You just treat, you know, teach the parole evidence rule or the statute of frauds, and the judges are making law. And they're making law, however, and Bickel acknowledged this in a very peculiar sense in which judges make law. There's a kind of disciplined creativity that's role related. But to go and say that it's either pure policy, just like you're a president or a representative, or you know, just simply reading, you know, getting the secret decoder book for the Constitution. When you get to the Supreme Court, you get up there and you get this little double lock key, like you're back in Get Smart, and you get the decoder ring. Neither is conveying to the people, I think, what it accurately means to judge. And what judgment is. And unless we can do that, I don't see how we can save any kind of integrity for the court. They've got to explain what they do in a way that's neither, that's not a myth.
An analogy to that is we'll be reading when the World Series starts, we'll read about which umpires have a narrow strike zone and which ones have a wide strike zone. So calling balls and strikes is, even in baseball, is a little more complicated. Let me turn to an offspring of this. The Supreme Court, obviously, federal, almost half the federal judges have tenure for life. Supreme Court certainly does. But they make decisions which are obviously influenced by ideology to some extent. Chief Justice Rehnquist referred in a speech in 1996 to the need to have a popular imprint on the judiciary. Those were his words. Lest we have the view that the country's going to be forever under the rule of unelected judges. And he said the way we get that popular imprint is we popularly elected presidents appoint justices or nominate justices, popularly elected senates confirm them. And up till about 1950, justices served maybe median, it was about 11 to 15 years. And most presidents got to appoint make two appointments each term. It worked out that way. That's changed. Now the justices are serving 26, 27 years. And when President Trump got 3 appointments in a single term, he was way ahead of Obama, who had 2, Clinton, who had 2, George Bush, who had 2. So the question becomes, are we still able to maintain a popular imprint on the judiciary? Especially, I don't want to get partisan myself, especially when we have a court, 3 of whose members were appointed by a president who, by any account, lost the popular vote rather significantly, and 2 others by a president who at least entered office that way. And I don't mean partisan, but I'm just trying to analyze this dynamic that Rehnquist and others, political scientists, have talked about may be escaping us. Any thoughts about that and whether or not that's dangerous to the court's legitimacy?
Let me go first, but I'll be quick. On the issues of the confirmation process and also on the terms of judges, I got to be really careful about what I say. I'm serving on a government commission that's studying some of these issues. So I'll leave that to Kathleen and Randall. I will say, just on a very high level of generality in the confirmation process, listen, obviously the process is very, very ugly at times, and surely for a variety of reasons. One of the things, though, I think gets overlooked in the melee is that the confirmation process has served over the last many decades as a very useful constitutional conversation for our country, for nominees from presidents of both parties, an opportunity both for the public through their elected leaders to offer thoughts, sometimes blunt, sometimes out of bounds, I think, on how we ought to think about the Constitution today. And I think it also serves a function in the other direction, where you have now basically for the Supreme Court always sitting judges, almost always sitting judges who are nominated to a higher seat, trying to describe the work of a judge in maybe the most highly publicized forum that we have for such matters. And so I know that Rehnquist and Scalia in some places, including his dissent in Planned Parenthood versus Casey, talked about the conversation that happens from the public to the nominee, and that's important, of course. But I think also we ought to value in the confirmation process the conversation that happens in multiple directions. And again, I think try to look for opportunities to make it the best version of itself.
I totally agree with you on that. And I think that let's go back to the confirmation hearing that was actually the most notorious, the Bork hearing. I mean, the fact of the matter is that there was actually a good a constitutional discussion. He was very forthcoming. He was very candid, and it was very instructive. The tragedy is that because people are, in a sense, trying to escape politics, there's this reach for scandal. It wasn't enough to disagree with the person's politics. You had to try to find out something. You had to try to cover that up by making the person look like a bad guy. And so, for instance, with Judge Bork, now, you know, Judge Bork ideologically, totally my adversary. Mm-hmm. But he was a distinguished jurist. There's no question about that. A distinguished jurist. He was being very forthright. And the problem is people really did mistreat him. Mm-hmm. And subsequent to that, there has been a sort of, like I say, a flight from politics. It would be so much better if people were straightforward, if there was straight talk, and realizing that, you know, politics is an inevitable part of this. No, it's not totally how did somebody somebody woke up on one side of the bed this morning and they just sort of had something in their mind. No, that's not the way the judges operate. I think, Kathleen, you're absolutely right. There is a discipline. There is a professional socialization that these people go through. So it's not just whim, but it's also not just being, an umpire. There's something in between, and I think we need to focus on that, but we can only focus on it if we are willing to be more candid than we are currently willing to be.
And I agree with that. I mean, I think the Bork hearing really distorted the entire practice of not just the confirmation hearings, where the idea seems to be pull your head into your little turtle shell and say as little as possible to give people a reason to vote against you. So I'm not sure. I mean, I totally love Adam's idea of what a hearing should be, a dialogical, relationship in front of the whole people. But I think I'm not so sure it is that. So there's the hearing itself, and then there's the process. If you're the sort of person who wants to be a federal judge and wants to be on the Supreme Court, you have to run your life in a certain way so that you say as little as possible about anything that could be entirely controversial, or even the slightest bit controversial for many, many years. And you might make it and you might not. So I'm concerned about the distorting process of the confirmation hearings, not simply on the Supreme Court justices when they get to that point, but on the whole group of people who aspire to that position. So I think that's a serious problem. What we're making our future judges go through may very well warp their judgment.
I'm just two comments. One is I would push back against the idea that, but for the Bork hearings, the confirmation process would be moving along smoothly.
Not smooth.
But for Bork, everybody would be sitting around singing Kumbaya. I mean, I think the confirmation process has gotten more contentious because American politics has gotten a lot more polarized. And even without Bork, I think we'd have the situation we have. Let me just make one last effort and see if anybody wants to pick up on it, then I'll move on. What about, though, this notion that for most of the court's history, the justices served, I'm not advocating term limits, the justices served maybe 11, 12 years. Presidents routinely replace them. So that in Robert Dahl's words, one of Bickel's colleagues at Yale, the court was generally consistent with lawmaking and majorities. Now we have justices serving 26, 27 years. Yeah. There may be presidents maybe appoint 2 or so. That whole notion that we keep the unelected judiciary to its democratic norms by that process has gone out the window. Shall we drop that, or would anybody like to pick up on it?
I'll pick up
let
on
it
it.
Go after that.
I think it does raise a point. I mean, people care about what happens in their lifetime. And, the Constitution, I think we talked about it in our pregame show for this. It doesn't have any age requirements for judges. It doesn't even require that, you're a lawyer. So you could have, there's nothing to stop, theoretically appointing a particularly bright, 22-year-old, to the court. So if you don't see any hope of change in your lifetime, I don't think that, that actually helps. And then I don't know whether it's luck or fate or divine providence. I remain agnostic about the cause, but the Republicans have had much more luck in getting justices appointed, it seems. I seem to think that there were statistics, at least in recent years, that the Republicans have appointed more judges. So if you think that luck or fate or divine providence is against you, and the age limit is long before you may not be assuaged by the idea that don't worry about it. Someday a president will come along and appoint somebody who can change things.
Also, behind your comment was the whole question, the life tenure.
Right.
And so, should that be revisited? People live a lot longer, and then you have people. There's obviously, I don't know if it's obvious, but it seems clear to me that there's an effort on the part of political figures to choose judges who are going to stay on the court a lot longer. It's not just happenstance; it's planned. And so, should judges, you want to maintain some degree of independence. On the other hand, do you want people to be on the court for 20, 25, right. 30 years? It seems to me there have been a number of people, especially in the past few years, who've said, well, let's have a long enough for judicial independence, but, what about 15 years as the cutoff? I think that we should be thinking in those terms and should be maybe revisiting the question of life tenure.
And I think that's a much better path toward thinking about reform than something like court packing, which the more I read about, and you are all more experts in this than I am, strikes me as something that is, is not in line with what the court is. And it can be just like the filibuster, use one side or the other. If you had 18-year, I think was the proposal, was it the Calabresi proposal, 18-year term limits, you might be able to do something workable.
18-year term limits, and you wouldn't need to amend the Constitution because the justice would have the choice then of serving on the Court of Appeals if he or she wanted to. Let me shift the conversation a little bit. And we talked about this, as Kathleen, you said in the pregame show also. We refer to the Roberts Court. Chief Justice Roberts has been Chief Justice now for 16 years. He's 66 years old. He may serve to 80, he may serve 30 years. Any comments about how Roberts is doing, about the role of the Chief Justice? It was referred to the Roberts Court, although now with 5 conservatives, people are, and Roberts has tried by his actions on the court and off the court to keep the court above the partisan fray. He may be have been marginalized a bit by the last 3 Trump appointees. Any desire to talk a little bit about the role of the Chief Justice, how Chief Justice Roberts is doing, whether the Chief Justice is too powerful, not powerful enough, or not?
Adam, why don't you take that one first?
When the chief had been on the court for 10 years, I wrote a long magazine piece about his tenure, and I tried to think about it in terms of 3 kind of nesting questions. His view of the federal government's role in our constitutional system, his view of the court's role in our federal government, and his view of the chief's role on the court. And he's actually spoken eloquently to all 3 of those issues over the years, and he's continued to do so. I tend to actually have a pretty favorable view of the chief. I don't agree with everything he's done, and I think he's gotten some important things wrong. I think he stayed basically true to what he said he would do in his confirmation hearing and his earlier writings, to the chagrin, really, I think, of people on both the right and the left, or Democrats and Republicans. And I know there's a lot of sort of complaints, especially among my friends on the right, maybe also on the left, about him worrying too much about the institution. I think it's inevitable that the Chief Justice is going to think institutionally. I think looking back at our history, most Chief Justices have been shaped by their office more than they actually shaped the office. We know the famous exceptions, right? Warren, Marshall, Taft, but they're the exceptions. And I think more often than not, the office has shaped its occupant, probably in some good ways. And it's, again, not surprising after all, the Chief Justice's name is kind of on the door, the Roberts Court, the Rehnquist Court, and so on. And it's natural they would identify more than any other with their institution. I don't know that we would want a court of 9 Chief Justices all thinking about this in the same institutional way, but I think it's good to have at least one, it's good to have one and only one Chief Justice on the court, and to have one person thinking through a moderately more institutional lens than the other justices.
Any comments, Randall or Kathleen, on this topic?
Well, I think he's done I'm not as familiar as Adam is with the whole history. I mean, and I really appreciated your comments on that. And I think he's done a remarkable job. I write about rhetoric of presenting his positions in a way that invites agreement. So the rhetoric of, Roberts' rhetoric versus, on the one hand, even Kavanaugh or Scalia, I mean, it's just night and day. And I think thinking about even presenting your opinion as an invitation to agree rather than as a prophetic indictment of the opposition is a good thing. What I would say is that if the crisis in the court is one of democratic legitimacy, I mean, I do wonder whether some of his decisions, especially those on voting rights, and that, is going to actually impinge upon, his ability to lead the court and through the court to lead the rule of law. If you have a substantial number of people who think, what this is about is enforcing disenfranchisement of a certain group of people who are going to vote for the Democrats, and I realize not everybody sees the cases that way. I can't see how that is going to not impinge upon his reputation, even as a Chief Justice, precisely because it goes to the heart of democratic legitimacy. And that really is the heart of the role of the court's Chief Justice, I think, too.
Well, Kathleen, when your last couple of paragraphs grabbed me by the throat, because in my view, an opinion written by the Chief Justice, Shelby County versus Holder, was one of the an egregious case, in my view, a judicial delinquency. My sense is that the Chief Justice.
Voting Rights Act case for people who may not recognize the.
Yes, it was the voting rights. It was the case in which the Supreme Court of the United States eviscerated the Voting Rights Act of 1965.
Right.
Now, I think that the Chief Justice comes across, and from all I can gather, is in many respects a very decent person. He upholds he puts a good face on the Supreme Court, in the sense, I mean, if you were making a movie and you wanted to cast a person to be Chief Justice, if he were one of the actors, I think
Get the part.
you might choose him for the part. And so there's much good to be said about him. But I'll come back to my number one, just substantively, his participation in that case really, that's hard for me to take. And then secondly, to the extent that as Chief Justice, he, like Breyer, like Thomas, like Barrett, has talked about, the question of legitimacy, and the ways in which he's talked about it seems to me to be public relations talk.
Right.
It's we want you to see us in a certain way, as opposed to we want to make rulings, we want to comport ourselves in a way that is that actually wins the allegiance of the masses of people. So that's my view of the Chief Justice.
And I think that's why, I do think that's why, the Bickel point about like eventually the mask is going to fall. And, if the justices aren't in fact acting judicially and explaining what they do, people are going to not believe them. And then we do have a constitutional crisis on our hands. So it isn't just the soothing words that you say in the speeches. And that's why I agree with Professor Kennedy that the biggest threat to the Chief Justice's legitimacy as Chief Justice is decisions like the Shelby case, and then the more recent one whose name I can't pronounce. So.
Well, I want to turn quickly to, I'm sure we have questions from the people who are joining us on this event. I would just note, it's interesting. The Chief Justice is an important office. It has life tenure for reasons totally unrelated to its work as Chief Justice. The Fed chair is term limited. The FBI director is term limited. All cabinet secretaries are term limited. We're talking about term limits for the justices. Might at least think about term limits for the Chief Justice, and whether or not somebody who gets appointed Chief Justice gets to serve in that post. For Roberts could well be there for 30 years total. He'll take over Chief Justice Warren's a tenure record this year, and he'll approach Justice Burger's, and he'll be close to Rehnquist pretty soon. John, are there questions that are coming in from those who are joining us on this program in the audience?
If the Supreme Court has done something to undercut its legitimacy, what specifically, in your opinion, has it done to do that? Is there anything specific that it has done to do that?
Anybody want to take that? In other words, the question is, if the court's legitimacy is being undercut, and some of these surveys suggest at least it's dipping down from where the range it has been, what specifically has it done to lose public trust?
There are a couple of cases that immediately come to mind. Bush versus Gore.
Right.
I clearly remember it was on the week. It was on a weekend, and I was at a meeting, and someone asked me about that, and I said, well, long tradition, the justices are not going to get involved in this. I think a lot of people were very surprised by the justices getting involved, and then they were even more surprised by the rationale. If one reads that opinion, that's one that immediately comes to mind. And then there are others in which, as I said before, I think that there are parts of the country that have the feeling that they're not going, that their interests
Right.
are not getting the sort of attention that people would want from the Supreme Court. Foremost in my mind, frankly, organized labor. I think that immediately comes to mind. I think that consumers, and I think racial minorities, particularly Black Americans. So these are parts of the country in which I think a person could reasonably think that, nope, I'm going to get the short end of the stick on this one. And, I don't think that they would be unreasonable in coming to that conclusion.
We're going back to footnote 4 in Caroline Products.
Right. Well, it was a good footnote.
Oh, sorry, go ahead, Kathleen.
Adam, you want to say something?
No, like Kathleen was about to speak, I cut her off.
Okay, Kathleen, then Adam.
Just quickly, I think the question has 3 parts, and we've been talking about them all. One is the way the justices are chosen and the whole political campaign that, has been increasingly associated with them, the money that's spent in doing that. So that process around the nominations, I think, delegitimates. Second, I think you've got a more fundamental delegitimation when it comes to Citizens United, when it comes to, it doesn't look to some people and the voting rights, that the conditions of full and fair representative democracy are being maintained by the court, but that it seems to be going, toward a partisan rather than a political direction. And then there are the hot button cases themselves, where it looks like the court is taking a particular side, such as Professor Kennedy said. So I think those 3 elements are contributing together to the delegitimization of the court.
Adam?
I was just going to say, from basically Alexander Hamilton onward, a lot of people have written about the legitimacy of the courts, not always in that term, but I think it's fair to say, at least my view of it is, they've often spoke about basically 2 things at once. One is the legitimacy of sort of an objectively correct approach to judging. They're not necessarily all originalists, but even Hamilton wrote about what would make a good judge. But he also would write in terms of the need of all judges to maintain the respect and the affections of the people, even when they're disagreeing with the immediate desires of the people. And so you have those twin sort of objective and subjective standards of legitimacy twirling around each other throughout history, and it's often, I think, difficult to disentangle them. I think debates about the court's legitimacy, they certainly aren't new, especially not even in our modern era. I mean, in the 1990s, when the Supreme Court decided Planned Parenthood versus Casey in a way that disappointed many conservatives, a lot of, I think, serious and thoughtful conservatives basically lost their minds in debates over the legitimacy of the court. And even Alexander Bickel, and here I think he was definitely right, he had concerns about the court's legitimacy in his later books, going from the latter part of the Warren Court into the Burger Court, and his writings in the New York Times and commentary and elsewhere in the early 70s. He was profoundly worried about legitimacy. So I think it's important to keep both these things in mind, or to keep this in mind, but also to understand that we're often talking about 2 things at the same time. And as Bickel himself wrote in The Least Dangerous Branch of the counter-majoritarian difficulty, there are going to be times when the court is out of step with immediate public opinion, and maybe even over a span of years. And that's why the obligation of the court, as Randall has said a few times too, the obligation of the court and Kathleen has said, to explain their decisions in a way that tries to win not necessarily the agreement of the people, but the respect of the people, is a profoundly important and undervalued part of the work of the judge in our system.
Just to push back a little bit, I mean, so Bickel said, yes, the court is going to be leading the people. It's got to be out ahead, but it can't be too far out ahead. And, it somehow has to create a consensus. And so you might be, one of the things I'm thinking about that might come up, Roe v. Wade, of course, is one of the most contentious decisions that was, handed down. And, there's many people think, I suppose we'll just have to wait and see, that the Supreme Court will either, overrule it or dramatically cut back on it. But then you have, and so that was an unpopular decision, but then you have Obergefell, which, constitutionally protected same-sex marriage, which is I think, looking at the sorry, I've got the relocating R problem from Massachusetts. Looking at the data, people are very supportive of that decision. And so how does a court thread the needle, when, Obergefell and Roe seem to, be of the same type of jurisprudence, Casey, right to self-determination, right to privacy. If you're only looking at outcome, you're going to have a problem saving one and getting rid of the other. But, that seems to be what Bickel would think we should do, at least partially.
I mean, if I may, just really quick, I mean, for Bickel, and this is where my Bickelian stripes really do come through. I agree with Bickel completely that sometimes the court is out ahead of the people in a given moment. For Bickel, it was so important for the court to really root when it's leading the people. He's leading the people back to sort of the best version of themselves, which is to say a version of themselves that really does justice to the most important strains and threads of American tradition and history. And for Bickel, in the era of Brown versus Board of Education, it really was about teaching people what the line from the Declaration of Independence through the Civil War really meant, even when after nearly a century after the Civil War, the American people tragically too often did not understand what where their tradition really pointed.
We want to get to other questions. I can't let this question about legitimacy go by there without just saying briefly. I have to say that the musical chairs that a certain senator played with seats on the Supreme Court and the preposterous justifications he offered. I'm talking about the Senate Majority Leader, now the Minority Leader, to seat certain justices and not seat certain others has to have taken a toll, certainly in the minds of some people who thought that he was just playing with the court. Enough said on
I
that.
agree.
John,
I
another
actually
question?
strongly agree with that.
That actually was one of the questions that we got as this conversation went on was, I trust you're talking, Russell, about the Garland.
I'm talking about the
nomination.
Garland and rushing Justice Baird on the court as the vote was actually starting. Yeah, both of those.
And so the question had to do with the impact on the legitimacy of the court.
And I think some people are likely to perceive that more than they. These surveys I mentioned, there's a fair number of ignorance about even major cases before the court. People just don't know that, but they have a sense that something's wrong, and I think that has to have contributed to it. But anyway, I'll get off my soapbox.
No, I think that's right, because the fundamental question of fairness, right, is treat like cases alike. That's what being fair means. And it's very hard to find a distinction between, what happened in Garland's case and what happened, in Barrett's,
And the historical justifications offered just hold no water whatsoever. There's just nothing to them. John,
it seems to be just we should win, and then you get to result oriented.
I mean, for what it's worth, I'm much more sympathetic to the non-vote on Garland. In fact, when I was a student toiling away in Professor Kennedy's school about 15 years earlier, I wrote my paper as a third-year student on why the Senate didn't need to vote on judicial nominations. Now, that said, I will agree that the migration of arguments from 2016 to 2020, and there were many kinds of arguments at both times, but I think the clear change in tenor from 2016 to 2020 did have a very detrimental effect. And here I'm just repeating what I wrote at the time, so I don't feel like I'm talking out of school with respect to my work on the commission.
So we have a question that's kind of ties to what you all are talking about. What does originalism mean, and is it a good thing in your view? That's a big question.
Yeah, we'll knock that off in about 30 seconds. Who wants to start? Adam, you want to start?
I feel like I'm talking too much, but originalism is the view of the Constitution that says judges should interpret the law and decide cases in accordance with the original public meaning of the law. Now, professors can spend an entire semester or more explaining what that may or may not mean, but that's basically what it means. And I, for one, think it's a good thing. It's not a cure-all, but I do think it's a good place to start.
I have to say, there are certain versions of originalism that I'm more sympathetic to than others, but my fundamental attitude toward it is puzzlement, right? I mean, I'm not sure, for one thing, how and why we should interpret a charter for a society moving forward indefinitely into the future can be tied to the original meaning. It's almost like it was coded by the founders and then is decoded by us. So that's one problem. And then secondly, for me, more important than originalism is interpreting the Constitution as a piece of law in the common law tradition. And if you're interpreting law in the common law tradition, the English common law tradition, which we didn't actually overturn, but endorsed, then I think there is room for disciplined, organic development. What I worry about when I read some versions of originalism is that it's actually moving out of a common law system back almost to a code system, where you go back to the original document and interpret that and apply it to the contemporary context. And that puzzles me, because we are not a code-oriented legal system.
I have three things to say about the originalism. One, just a question: were the founders originalists?
That's right.
Did they were the founders? What did they think about originalism? That's a question. But then I have two comments. One, it seems to me that as I've seen people struggle with originalism, I think that what Adam said is absolutely right, that one idea is that it would discipline the judges. It would prevent them from sort of going off their own way. But I don't see it actually having that disciplining function. I have seen people who take a look, who think of themselves as originalists, and they go over here. And then I've seen people who at the very same time, very same text, very same history, go in a completely different direction. You can have originalists of different ideological persuasions that go in different ways. So I don't actually see it disciplining. It seems to me that it's pretty indeterminate. And then finally, and frankly, most importantly, is the problem of values. So, there are people who say, well, any theory of constitutional law that would lead us to eschewing, rejecting the conclusion of Brown versus Board of Education is a bad theory. Well, it seems to me that a thoroughgoing originalist would say, no, Brown versus Board of Education, not so good. Even more so, Loving versus Virginia.
Exactly.
The case in 1967 where the Supreme Court of the United States struck down laws prohibiting marriage across the race line. It seems to me, if you are an originalist, there is plenty of evidence that the framers of the 14th Amendment were okay with laws that would prohibit marriage across the race line. So, I don't want our society to be shackled to bad values that are rooted in the past. So I'm against originalism, and I think that a lot of the time now, when people say that they're using it, oftentimes they're using it opportunistically.
What I also wonder is, and maybe Adam, this is a question for you, but I have a hunch that some members of the conservative movement, when, say, Roe was overturned, are going to move from, and I've seen some writing on this, are going to move from being originalists now to being kind of natural law, frozen in 1789 kind of kind of a natural law approach that's moving away from saying, well, the court can't say anything about this because the Constitution doesn't say anything one way or another about abortion, to imposing and importing the values of that time. So moving from an originalist textualist approach to an originalist, we're embodying all of the values in 1789. To pick up on Professor Kennedy's point, we will have values, but they will be the values of 1789.
Can I speak to this just a moment, Russell? Because these are good questions. And I want to say, just to be very clear, I agree with Randall that if you have a mode of constitutional methodology that doesn't bring you on the right side of Brown versus Board of Education, your methodology is going to lose, and it should, given how out of step I think the values of segregation and everything, much less everything that preceded it, were out of step with the basic founding principles of this country, even if the founders themselves were total hypocrites to start with. And so, there are some thoroughgoing originalists like Michael McConnell and others who believe that there's a straightforward originalist defense of Brown. Now Bickle himself disagreed with this very much, and since we keep talking about my hero Bickle, but others would come out the other way on that. On Kathleen's point, and this is very, very important because it is where I do see the limits of originalism. Laws don't interpret themselves, and of course we can call them value judgments, but there are principles that are not written in the text which are going to inform our reading of the text. I totally recognize that, and I try to be mindful of that in my own work. Right now on the right, there are very interesting debates among conservatives who would agree at a very general level about originalism, but disagree about what principles or presumptions should undergird it. Libertarians have been for 15 years now been making arguments about this. You now see natural lawyers often under the rubric of what they call common good constitutionalism. Hadley Arkes and others arguing for those principles in the law. My own style of originalism, and I don't pretend to be any of those giants, I'm just toiling away at AEI, but my own version of originalism, I would like to think of self-consciously as Republican originalism, small r Republican. Understanding that the courts have an important but limited role in our constitutional government, and that the judge's work is not just to interpret the law mindful of the Constitution and then decide cases mindful of the Constitution. It's also to understand that in a republic, there are special duties of how the judges ought to hear what the people are saying and speak to the people and justify their arguments to the people and have a pretty modest view of judges. Again, originalism is very important to me, and I think it's probably from my view, the most important thing a judge can do is start with being an originalist, but then to understand the limits of where originalism can take you and being very candid and self-restrained in the other values that you're going to import into the work of a judge.
So kind of tied to this conversation, the Supreme Court seems to presuppose that the Constitution contains answers to hard social and moral issues, even when a reasonable person could conclude that it does not. Same-sex marriage, abortion, for examples. Would it be helpful or not for the court to acknowledge more often than it does that the Constitution is simply silent on these kinds of things?
I think it'd be helpful. I think it would. I think if that's what your belief is, and I also think it'd be helpful if judges would. This is a close question. I think it'd be very helpful. The people on the other side have a good argument.
Yeah.
I'm torn about this. Again, I think that, Adam's point just a moment ago about, some degree of true humility would, actually, I think would be welcome.
And I think that's a really important point. And I thought what you said was really eloquent, Adam. I really appreciate the way you put that. And it resonated greatly with me in terms of what judges are. I suppose I am afraid that all of these contentious cases, Roe, Obergefell, all of them are framed in the idea that there is no reasonable disagreement, that, so the culture war framing and the rhetoric of prophetic indictment has seeped into the arguments about constitutional law. And what I find most, troubling is the sense that, there are good justices and there are bad justices, and the good justices are the ones that, that agree with me, and the bad justices are the ones that don't. And so that the idea is to get the whole court composed of justices who agree with me, nine little Scalias, or, 9 Earl Warrens. And I think that, if, to the extent that the court gets politicized that way, that the idea is we keep going and going and going until everybody on the court agrees with us, no matter what the country looks like. We don't have a way of saying, these are hard questions. We don't have a way of officially saying that.
Yeah, I think one of the most crucial parts of the work of the judge, on top of all what was just said, and Kathleen, thanks for your kind words. I think one of the most important things is the behavior that judges model from the bench, and that they can be seen as disagreeing with one another without hating each other. I think that's one of the reasons why people were so affectionate toward Scalia and Ginsburg once they sort of learned, because obviously Scalia could be very, very pointed with his opinions, and he probably went over the line sometimes. And Justice Ginsburg, she was no shrinking violet from time to time too. But I think when people understood that they actually were very close friends and very affectionate for one another, I think that was a great thing for the public to know. And so I think that the more that judges can be seen disagreeing with each other, sure, pointedly, but collegially, I think is one of the best services they could render today in exemplifying what it means to be Americans who are living together, even while we disagree with each other on such fundamental concerns.
Ready for another question. One of our audience members said that he or she had read the George Will article this morning about the secrecy of the FISA court, and that the Supreme Court may have to confront that, and that this person points to the legitimacy challenge in the federal court system when you have a court that, well, at least for a lot of the history of the FISA court, the decisions and the thinking were entirely kept secret. Do you all have comments on that? I don't know if you read the article, but I think the person did summarize it not badly.
Anyone?
Nobody has thoughts on
I'm thinking.
it.
It's true that I did some looking into some stuff about the FISA court in terms of who was getting appointed to it, and the appointments of most there's another thing, should the Chief Justice be appointing the FISA court members, but that's a different matter. It is a highly secretive, the way it does its operation, and it's kept its the few opinions it's issued, been very rare. I don't have any much of a comment beyond that. I mean, this is going to work its way, I presume, through the court system. I confess I have not read the Will article, so I'm just not going to opine on something for once, something I just don't have any particular, haven't rooted right into.
The only thing I would add maybe is, or suggest, and this isn't it's a comment that's more of a non-comment, is that this kind of secrecy in the history of the common law tradition, the English tradition, the Star Chamber, and various other courts that, were free of accountability and free of oversight, have proven to be very, very dangerous and bad under certain circumstances, under many circumstances. So I hope that whatever is done to kind of create a system of oversight takes into account, the dangers that come from non-accountability. And we've seen this all across, different spheres of, institutions, right? If you have no oversight, if you have no accountability, it's bad for every kind of institution, educational institutions. We've seen this in religious institutions, and it's the same thing in the judiciary.
I may on this, maybe to expand the question to transparency in the judicial branch more generally. There are some very interesting debates about this at all levels of the court. And again, I'm going to tread lightly around the ones involving the Supreme Court. But I just say at a very high level of generality, I think it's good for us to expect transparency of the judicial branch. It's also good for us to understand that the judicial branch, like all institutions, should have parts that are not necessarily constantly in a glass house. My colleague Yuval Levin, who helped organize the series, he often says that every institution needs to have sort of an interior place where at least some of the work can be done without immediate view. And the challenge for us, court watchers, the challenge for judges, the challenge for all Americans, is to really try to think through seriously what the proper limits of transparency are in both directions, where we need more transparency and where we need less. But I think we ought to, I personally find myself warning my friends, in talking about these things, that you can have too much transparency. I mean, I don't think that C-SPAN has necessarily made Congress a better place in the last 40 years, however well-intentioned it was. And so we ought to be very, very careful and on issues of transparency.
And that's why I think the key question is more, it's transparency important, but it's accountability. It's the relationship of what kind of transparency do we need and to whom in order to have accountability of the sort that will let the institution run in a way that doesn't smash the most vulnerable.
One thing is pretty clear, that you get a lot more transparency in the state courts than the federal courts. And the reason is the state courts are elected. I mean, they're just more accountable to the people. That you can say that's good or bad, but there's all sorts of areas in which that's true, recusal policy and a lot of other things. I noticed the Supreme Court, as I understand it, though, is going to allow live streaming of its oral arguments when it sits down next to begin its term, which most people would say, well, so what? But this is a momentous event, actually, that the Supreme Court's willing to have same time audio.
That will be a good or bad thing, right? I mean, the point about C-SPAN is well taken.
Well, yeah, let's get the audio first, and then we'll see about the video. But
this is we'll finish up with one more question. This is kind of a big picture one, and I don't know whether Adam has to recuse from it, but the person says, as I understand it, the organization of the federal court system hasn't changed since it was established by the Everts Act in the 1890s. Has the structure withstood the test of time, or should it be changed?
Well, it's true that the Everts Act, which established the courts of appeals with some minor modifications, is still the system we have now. And you get periodic arguments about whether or not you should have a 6-judge First Circuit Court of Appeals and a 29-judge Ninth Circuit Court of Appeals, for example. I mean, you can get all sorts of arguments in that range. I would say the one thing that has changed, this is one of the few things that have changed in the court, and it hasn't been a dramatic change, it's been a slow change over time. And that is and this is fundamental though, it's the gradual expansion of the discretionary jurisdiction of the Supreme Court. That hasn't happened in one fell swoop. It began in 1891, accelerated in 1925, and Congress has just gradually done that. So the Supreme Court has been turned, and this is fundamental, has been turned from basically a common law court to a policymaking court. That's the effect. And that's a fundamental major change, it seems to me. It's not a structural change, but it's a very important one.
I think that, expanding maybe the federal courts in the sense of, just expanding them. I thought Leah Littman had a really interesting point in there was a series on what to do about the Supreme Court a while back in the Times, and she noted that in the last 30 years Congress hasn't expanded the number of lower federal courts or authorized any additional Court of Appeals judgeships. But in that time, the population of the US has grown by almost a third, she's saying. The number of cases in district courts has increased by 38%, and appeals court filings have increased by 40%. So if justice for the most part is not done at the level of the Supreme Court, but at the level of the lower courts, I think there's a fundamental question about whether we have enough lower courts to do their job. So I think that kind of expansion would be a good thing. And I think she was right about that.
Although some of the people who argue most against expansion of the Court of Appeals are the Court of Appeals judges themselves. They're very leery of it getting too large. The Judicial Conference's request for new judgeships, I think, is limited to maybe 1 or 2. Where
we could get more circuits. I mean, you could split. I clicked on the Ninth Circuit, and I still regret the fact that I didn't get to sit in Hawaii or Alaska. But the idea that San Diego and Alaska are part of the same circuit, it seems a bit much to me.
Well, that's an eternal question. What we do about the Ninth Circuit. Any other comments about the federal courts and fundamental changes?
I think it's good that people are thinking about changes, big and small. I think that at this moment of such anxiety about the state of our political order, I think it's good that we are thinking about the judiciary, the legislature, the presidency. I think that all of these things need to be thought about, and that nothing, frankly, should be off the table. I think that a lot of people feel a tremendous sense of trepidation. And in light of that, it seems to me we need to free ourselves to think widely and deeply, and that's necessary given the state we're in.
And just looking at the circuit courts and the district courts, I think we should all keep in mind that it wasn't that long ago that Congress split a circuit, the Fifth Circuit, into the Fifth and the 11th. It's not that long ago that they created a circuit, the federal circuit in Washington with particular duties. These things can be changed over time, and I think it would be a mistake for people to think that matters of the structure of the lower courts are beyond the realm of sort of thoughtful legislation. And I think at all times the real challenge is, well, let me just say one easy thing. We probably do need more district court judges, and adding judges would be, I'm sure, tricky and fraught, but if there's a way to do it in a way that fosters, stability and so on over time, that's worth considering. I do think when it comes to changing the circuits, say, whether it's adding seats to the circuits, taking seats away, or splitting circuits, at the end of the day, the question has to be, what changes are most conducive to helping the court best operate like a court? And to the extent that I'm thinking here, since Kathleen mentioned the Ninth Circuit is huge. I don't know whether we should split the Ninth Circuit. There's some people like the idea, some people don't, and splitting it might be really, really disruptive. And I'm against disruption. But I also know that a huge court like that is hard sometimes for the judges to really operate like colleagues. On the other hand, you look across the country at the First Circuit, where it's very, very small, and I haven't looked at the statistics lately, but I know they've been very, very busy at times. And that probably too makes it harder for the judges to really act like judges. And so when it goes to questions of, do we need to adjust the structure of the lower courts or something, I think the underlying question really needs to be, what's the job of the judge, and what kind of structure in the district courts and in the circuit courts would best equip them to do that job? And then the last thing, sort of separate from all that, is there are real good questions right now about remedies. You see debates about what we call nationwide injunctions. Should one district judge have the power to stop an entire federal program? That's a very, very difficult question in a country where, it seems weird to allow one trial judge to stop an entire program dead in its tracks. On the other hand, rights matter and law matters. And if a federal program is out of step with the law and rights, then it probably should be stopped. And so I think we do need a sort of a serious national policy discussion about the remedial powers of the lower courts.
The only thing I would add to your point is it's not just about the judges, right? It's about allowing people who have cases to have their day in court. And if we've got a federal court system that is unable to handle that, very basic right to really due process, in a sense, any kind of process, then I do think we have to consider what the people need, not just how the judges conceive themselves.
I would just add that it takes a crisis to affect major changes in the federal courts. We should talk along about changes, but the Fifth Circuit got split once the judges on the Court of Appeals said we just can't function like this anymore. It reached that point in civil rights. It's very hard to change the federal courts. Just to make incremental changes are one thing. Bigger changes like that, boy, they're tough. They're tough to pull off. That doesn't mean we shouldn't keep talking about them, though.
Well, we're out of time, and I just want to wrap up by saying that speaking for the Library of Congress, but also for the Brookings Institution and the American Enterprise Institute, we're honored to have had such an esteemed group of scholars in this conversation, and what a fascinating conversation it has been. Thank you all on the panel. It's much appreciated. And also thank you for joining us in the audience.